Good evening. The curtains have been drawn today in the famous case between Devasthanam and the residents before the first additional district court in Tiruchirappalli. The records have been perused by the 11th first additional district judge, and the matter has been posted for judgment 20th February 2026. After a long battle spanning over several decades, for the first time in the history of this district, we have raised an issue that Devasthanam may not have title in respect of the property on very many grounds. One, in respect of the buildings which have come into existence prior to the entry in the non-fair register of the year 1910. And the lands which continue to be lands and garden on the advert of the Abolition Act 30 of 63. The primary contention of the Devasthanam is the property covered under Title Deed 27 is the absolute property of the Devasthanam, granted by some rulers whose origin cannot be traced. They have relied upon the entries in the non-fair register and contended that the temple has got right over the property, and this right has been acceded to before the settlement Tahsildar in some of the proceedings which went to the tribunal before the subordinate judge Trichy, and subsequently some of them before the Honorable High Court by way of an STA. The cases have been divided into two. One in respect of the building and the other in respect of lands. However, both of them are covered under the very same title deed. We have raised four important issues. One, the Devasthanam, represented by the Joint Commissioner, cannot file the suit because the Board of Trustees were in existence at the time of filing this suit. P, given the fact that very many alienations have taken place and the government has also recognized the right of the residents and the occupants of the property, the temple cannot file a suit for recovery of possession without seeking title. 3. The entry in the non-fair register in respect of case number 25 and 15.2 clearly denotes that the temple has got only a mail warrant and not the proprietary right in the soil. 4. The residents continue to occupy the property for more than 150 years. They have received compensation at the time of land acquisition and has also been recognized in very many proceedings. And especially one Mr. Varadachar, who went to the High Court on two occasions. One was dragged on by the Srirangam municipality for the enhancement of the compensation for land acquisition, and another in respect of a Melvaram right to the Devasthanam and not a Kudivanam right. And both of them, Varadachari succeeded somewhere in 1944 and thereafter in 1980. Varadacharya, according to us, as the savior of this town. He went to the High Court twice and got favorable orders. 5. The temple has also dealt with all these properties before the Abolition Act as though they have got only a bare or right. One third party mortgaged his property to the temple in 1902 and obtained a loan from the then trustees of the temple. the temple treated that property as a private property. B. Yes, the Devasthanam purchased the property in the year 1963 in South Chitra Street. C. One Dhanuraja Swamiji purchased a property in the 30s and he executed a settlement deed in favor of Devasthanam somewhere in the year 1937. And Devasthanam accepted the same and thereafter leased out a couple of shops in South Bazaar. D. The residence of Giant Commissioner was admittedly given by way of a gift to the Devasthanam by a private occupant which is situated in North Chitra Street. E. Government has also given an assignment to a private property in East Ravajan Street. F. Land acquisition proceedings commenced with regard to drainage in respect of Uttara Chitra at Adavalajan Streets and beyond that, which commenced somewhere in the 1920s, ended in 1942. Then all the proceedings ended in favor of the residents, where the residents got the occupation. These are the factors which show that the Devasthanam has got only a Mervaram right and not a proprietary right in the soil. Why number 5? The residents have got an absolute and exclusive right over the property. They have dealt with the property as their absolute property by continually registering the documents by way of a sale, gift, bargain, etc. for more than 125-30 years. We have filed almost 384 documents. Almost as an afterthought, the Devasthanam, as a railroad action, took some novel steps somewhere in 2022. Although they are also reclaiming the properties which are in the hands of Srirangam municipality or the Tahsildar's office. Quite ironically, the government or the municipal corporation did not even care to take a stand, whether they are with the residents or with the Devasthanam. You can imagine the plight of the common man when your own representatives are spineless. They never represented us. The corporation to whom the notices have been issued with regard to the municipal office building and the collectorate with regards to the taluk office and some of the public offices did not even care to reply, forgetting for a moment that if they don't do it, they will be ending up paying a huge money to the temple. The fact of the matter is that those are the properties or the absolute properties of the public bodies, namely the government, the corporation, but they refuses to acknowledge or refute the title or the alleged title of the temple for the simple reason that once they took a stand, it will be beneficial to the common. Your own representatives, many of the councillors, the MLAs or the MPs doesn't even care. Why? They don't represent us. They want to side with the HRNC because of the present climate, where the government, whether this government or any predecessors, doesn't want to antagonize some of the people who think that they want to retrieve the absolute properties of the temple. Absolutely, we have no qualm about that. If really it is the property of the temple, we don't have any problem at all. It acceded to such a demand. But the point is, in respect of the buildings which were in existence before 1910, The entries in the Inam Fair register show that it is in Nattampuram. It is a common knowledge that Nattampuram is not the property of the government. And if it is not the property of the government, it could not have granted a Inam to the temple. Therefore, on a simple logic, when the IFR itself says that the houses are in existence and there are trees and channels, and endorsement would say in column number 22 that it rests with the public at large and the government. There ends the matter. But the institutions of the present day cannot take such a stand because of some backlash from unknown. Therefore, they have caused innumerable hurdles in coming out some claim, a claim which is unfounded. They have admitted in the cases because this is a civil case which went on for a quite number of years. They have admitted that they were never in possession of these properties at any point of time. That means from time immemorial. The occupants are in possession and enjoyment of the property, which is an admitted fact. It is well nigh impossible for putting the onus on the residents to trace history beyond 200 years. A common man, if he occupies the property for 12 years, he will perfect the title. There was sort of things that however long you are in possession, it is entitled to recover the property. The one question which lurks in mind is, if the entire town belongs to Srirangam, there was startup. What for the temple is there? The temple is for the public. The public depends upon that temple. It is no doubt that the entire residents of Srirangam, in one way or other, is touched by the omnipresent Lord Raghunatha and Raghunathan. That once this is taken into account, a town with a temple but without any occupant is impossible. The answer is certainly no. If the answer is certainly, it can Devasthanam claim right to the properties. The another point which was discussed is about the two streets in which there was car festival, temple festival, etc. And some of them would say that it belongs to the temple. If it is so, very well within the four walls, these festival could have been conducted. These festivals can and only be conducted in the streets where people are there to worship their Almighty. It is not a temple town. It is not a temple or a temple property as such. It is more of a temple town. A combination of four prakarams comprising of the temple, Lord Raghunatha, Lord Raghunathan, and the sub-temples. And the outer three prakarams are the people who depend upon this Almighty, who refuses to go elsewhere. Their devotion and their way to be near the Lord can never be questioned. The fact that the temple or the Devasthanam doesn't have any documents except the Inam Fair Register, and the Inam Fair Register doesn't recognize the right of possession, And when the land acquisition authorities some 70, 80 years ago held that it was only a Melvara right, and the Devasthanam willingly accepted the same, and has also deposited before the court that we have applied for the compensation and we are yet to receive it after 80 years. These are the factors which have been thrashed out before the sometime in the last quarter of this 2025, the trials were over, and subsequently the arguments were commenced before the first additional district court, Trichy. No doubt, the learned judge was so patient in hearings. For more than a week, Devasthanam lawyer argued, and he has also placed some materials and some of them interpretation, not only disruptive but also against the canons of law. One of them was interestingly that idol is a perpetual minor, and therefore the question of limitation does not apply. We have replied that in the famous Ayodhya case, the Honorable Supreme Court kept a conclusion that idol is not a minor insofar as Limitation Act is concerned, which is the unanimous judgment of 5 honorable judges in the Supreme Court. And I hope that this binding decision will be taken into account by the court too. Very, insofar as our contentions are concerned, we have argued the matter for nearly 25 hours, so spanning over several days, and importantly, in the third week of January after Pongal, on Friday, Saturday, and Monday. The entire time was allotted to us. We have argued from 11:15 to 5, which was preceded by 3 earlier sittings of spanning over 1.5 hours of 2 hours. And thereafter, Mr. Vamsidhar argued, and the Raghuvaran Gopalan was from Madurai, was requested to make his presentation in respect of a portion of the intricacies involved in the region. Thereafter, we have also replied for around 2.5 hours. The arguments were concluded somewhere in the 4th week of January 2026. And now the case was posted today. The 11th judge stated the periods of all the records. He has posted the matter for judgment on 20th of February 2026. The curtains have been drawn. Keep your fingers crossed. It is all a legal matter. It is not a case of a war or where families have no place. In a legal matter, it all depends upon fairness. To say the least, we have placed all the materials before, including the title deed 1027, which shows that the Devasthanam was recognized to have only a government revenue and not a proprietary right to the soil. Devasthanam, though possesses the original, refuses to file the document. Quite astonishingly, a religious institution doesn't want to file a document because it is against them. The religious institutions normally are expected to place all the material before the court and request the court to take a view overall to give a judgment. On the other hand, surprisingly, title deed 1027, though in the court packet of Devasthanam, they never filed it for obvious reasons. We have filed it also. That's not. The After strenuous exercise, we have found so many documents, despite the fact that many of the residents never cooperated in giving their documents of their predecessor a title, which we have requested for more than a decade. Fortunately or unfortunately, we were able to answer the land acquisition proceeding comprising in 7 volumes, which we have also filed to court, and some of the documents which were against the Devasthanam. And the Devasthanam did not even address the issue of how it has happened. Why a mortgage the Devasthanam was involved, why they went ahead and purchased a property, why they accepted a settlement deed executed by Jalaraj Swami and recognizing it by leasing out to third party. These are all things, matter of record, which are ever before the court at any point of time in the past. We have done that now, and we have to thank a couple of people for that. One of them is Mr. Chillappa of Trichy Street, and the other is retired Tahsildar Rangarajan. Apart from Mr. Suresh, Raghu, Achugutu Banu, Jagannathan, Ramesh, FOCG, etc. This is a legal battle. It is a case where we want to prove that the residents don't depend upon Lord Bhagavan. They never encroach into the property of Lord Bhagavan. Quite unfortunately, in a battle between Devasthanam and the residents, unnecessarily, the Devasthanam brought into picture Lord Bhagavan, stating this is the property of idol, etc. Idol has been brought to the level of sub-article by Devasthanam. We have got a great reverence to this Almighty, and everyone depends upon this Almighty for their bliss. Since the matter is now over, at least before the district courts, I hope that one way or the other, the decision will have a great impact on the society in Srirangam. The fact that Devasthanam is willing to fight shows that this fight is not going to end. This batch of cases, according to me, is totally test cases. Others may have to follow. How they will follow, God only not another rules. Therefore, since the matter is posted for judgment on 20th and likely to be pronounced on 28th soon thereafter, I request all the residents and occupants of this great town to keep calm. This is the hallmark of this town. We never had any confrontation with anybody. We will continue to do the same. We so that Lord Ranganatha and Ranganai will give a solution to this man-made problem, which could have been settled long ago, but for the recalcitrant attitude and indifferent view in which this matter has been seen by the Devasthanam as well as the HRNC, painting everybody as though a trespasser or a encroacher into some temple's property or Devasthanam's. Keep your fingers crossed. Pray to Lord Ranganatha and Ranganai to give you a good solution. Thank you.